Hello everyone, myself Dr. Sarita Singh, Assistant Professor, School of Legal Studies, Babu Banarsi Das University, Lucknow. Today I'll be dealing with the topic research. In this, I will be dealing with what exactly a research means, what is a legal research, what is the purpose of research, what are the characteristics of research, and what are the types of legal research. First of all, we before we get to know about the research or legal research, we should know that any legal profession cannot move forward without research and findings, whoever it is, advocacy or it is academics. The main reason behind this is the dynamic nature of law. Legal research forms an integral part in the life of law professionals, whether they are students, lawyers, academicians, practitioners who are interested in legal knowledge. Even if you are someone preparing for a career in law and trying to understand what kind of education is needed for a lawyer, legal research will come in handy. With the changing of society and laws every day, it becomes essential to scrutinize the pool of laws and social rules. The primary purpose of legal research remains to either find the lacunas in the laws so they are made following the society's need or add some vastness to the subject matter of rules to make it comprehensive. When it comes to the meaning of the research means to investigate, to inquire, or probe in any particular area of discipline, whether it is a legal field, sociological field, economic field, any type of research. It is a careful and detailed study of a topic to gather more information about it. This can be done by adding, deleting, updating, separating, or correcting the previous knowledge. If I quote in the words of M. Stephenson and D. Slinzer, uh, in the Encyclopedia of Social Sciences. Research is the manipulation of things, concepts, or symbols to generalize to extent, correct, or verify knowledge, whether that knowledge aids in the construction of theory or the practice of an art. There are few objectives while we conduct a research, like to contribute to the existing field of knowledge in any specified discipline, whether it is a law, sociology, or anyone, to get a better understanding of how to formulate policies to answer specific area of a question of fact. This is what we research, we call. When it comes to the legal field, what exactly the legal research is. When it comes to the lawyer, law faculty, law students, when it comes to the law, to what exactly the legal research is. When it comes to the law is a subject that has broad dimensions of knowledge in society. There are several laws in India, which make it difficult for a prudent man to remember them all. With the growing needs and challenges of society, laws also have to change. This means the area of law is as dynamic as our society. A complementary relationship of law society here comes to play a vital role. Therefore, sometimes it becomes essential to review the laws and see whether they are suited to the best interest of society or not. Here, legal research comes into play. A systematic finding and ascertainment of the law on any identified topic to advance the science of law is known as a legal research. Legal research is a broad area that leads to an inquiry, investigation consistently made by judges, lawyers, advocates, law students, legal researchers, law faculties in the quest of a deeper and fuller understanding of the law. To support legal decision making, legal research comes into the limelight. It defines and retrieves the information to make the complex process simplified. Now we come to why we need legal research. What is the purpose of legal research? As already we have discussed earlier, like up in just before a minute. Law is dynamic, as a society is. It operates in a complex structure of society. Behavioral norms and attitudes are controlled and molded by the law. However, with the nature of these norms changing with time and space, it becomes essential that law becomes adaptable to the changing order of society. Legal research is also essential to write plagiarism free content. Plagiarism is a common practice with severe consequences. Most students avoid legal research and stick to paraphrasing or plagiarizing from the content written by others. This can lead to serious consequences such as a copyright complaint, a penalty, deduction of marks in universities, in your class tests, in your assignments, etc. So, legal research is an essential step to avoid resorting to such practices. Here, in such a situation, legal research becomes essential for the ascertainment of law, clearing ambiguities in the law, identify the weak points in a direction, and critically examining the order to ensure consistency, coherence, and stability in the law. There are various purposes for which uh, legal research are conducted, like uh, with various laws, rules, regulations, and existing in the society. It becomes essential to filter the laws presently applicable to the given situation. It is not easy to find the law or a judicial pronouncement at a particular point in time. Here, legal research makes the task easier. It makes the ascertainment of the law easier and much more helpful. It is not always true that law once made can never bring rise to any contingency in the future. There exist some ambiguities and gaps which might be removed with the help of legal research. The nature of law is both reactive and proactive in that it answers questions arising out of such ambiguities and gaps. Apart from helping in removing ambiguities, it also helps in determining coherence, stability, and consistency. Legal research also helps in predicting the future. Like it also helps to understand the social factors that had indirectly impacted the making of law. Social auditing of laws helps in identifying the gap between the legal and real and social reality. It helps in suggesting reforms based on analytical, historical, and comparative research. There are some characteristic which talks about like what is a good research. When we talk about the characteristic of good research, so these are which originates with a good with a question or problem, which requires clear articulation of a goal, which follows a specific plan or procedure. When you will say a good research is, when it often divides main problem into sub problems, when it guided by specific problem, question, or hypothesis, accepts certain critical assumptions, requires collection and interpretation of data, helical in nature. When we come to the kinds of the legal research, on the basis of many bases, like if we talk about on the basis of meaning, there are descriptive legal research, there is analytical research, legal research. When the method we use, there are surveys, there are comparative and correlational methods. Now, when we talk about the analytical research, there is already available facts and information which are used for this kind of research. When we talk about applied and fundamental research, the second kind of the legal research. In applied, like it aims to find the solution for the problem practically. When we talk about fundamental legal research, it is concerned with the generalization and formulation of the theory. Fundamental research, legal research is also known as pure research or basic research. And applied research is known as action research, which aims to discover a solution for a pressing practical problem. And in fundamental legal research, it aims to find additional information and thereby to add to the existing knowledge. Their third type of the legal research is quantitative and qualitative legal research. Quantitative, which talks about like questionnaires, surveys, structured interviews, and experiments. Qualitative, like participant surveys, unstructured interviews, and life histories. It basically concerned with the qualitative phenomena that is relating to quality or characteristic. When come to the quantitative, it is conducting research based on the numerical data. It seeks to measure the quantity or amount. When it comes to the next conceptual and empirical legal research, conceptual legal research related to an abstract theory or idea, like the philosophers, thinkers, okay, they develop or reinterpret existing concepts. When we talk about empirical legal research, it is done by relying upon experience or observation alone, often without due regard for any system or theory. Like you can say that it is also known as experimental research. That's all for today. Next in the other topic we'll discuss in next class. Thank you. Bye bye. Take care.